In today's episode, I'm going to be looking at the different ownership structures to help you make the right decision as to whether you should be buying in your own name, a company, or a trust. This is a topic that not only bothers first-time buyers, but also seasoned investors. There's a constant debate online upon whether you should be buying in your personal name, a company, or a trust. And much of what I'm going to be discussing today can be applied to you as an individual if you're simply buying for your own sake. But the focus will be on joint ownership. Joint ownership is something that I believe is very powerful in the property field. And I own property jointly with a number of different people, whether it be from my wife or to partners in business. I have a lot of joint ventures in the property space. So I personally own property in my own capacity, in a company and in a trust, and for different reasons. Those properties are in those different entities. So I can speak not only from education perspective of knowing the nuances of these different structures, but also from personal experience. Experience with clients where we manage and help them make decisions in terms of their structures and advising as to how to go about these things, but also in my own life, where I've been faced with this question many times before as to what the right structure would be. So in South Africa, you generally have three options when purchasing together. The first being purchasing jointly in your personal capacity. That would be where myself and yourself potentially buy property together, and it is registered in both of our names, whether it be on a 50-50 basis or a 60-40 basis, that we can discuss later. But essentially, the property is registered into the names of both parties, or all the parties that are involved in the purchase agreement. Typical scenario like this would be where husband and wife maybe buy a property together, especially if they are married in community of property. The property will automatically register into both individuals' names. Just to clarify that, so that you don't think that it's only people that are married in community of property, even if you are married out of community of property, but the two spouses purchase jointly, the property will be registered in both people's names. So this is probably the most popular example of a joint ownership structure where the property is registered into two individuals' names. The second option you have is buying through a company. This would be an indirect form of property ownership where you, as a shareholder in a company, own property indirectly through the company. So the company buys the property and is the owner of the asset, and you as the shareholder then have controlling interests and ownership, beneficial ownership of that property through your shareholding. The third ownership structure is that in the form of a trust. This is something which is also very often used in South Africa, but I think a lot of people don't understand the complexities thereof. So trust is a mechanism used for property ownership, but you as the founder or trustee of that property actually relinquish ownership of the property to the trust. The trust owns that property completely independent of you as a trustee or a beneficiary. Now, when deciding whether you should be buying in your personal name, a company, or trust, can be quite tricky. So we're going to look at each option because it has major implications, not only for decision making and processes in decision making, but also financial implications, access to finance, and then also liabilities and how you're exposed in terms of liability. So we're going to break that down, have a look at each of these ownership structures so you can make an informed decision as to what is actually the best one for you. So I think first off, let's have a look at why people consider joint property ownership. You may say, well, Rowan, I just simply like buying properties on my own. There are a number of different reasons why people look at shared property ownership. And the first would be shared cost. Okay, a property becomes more affordable or more achievable to afford if the load is shared between multiple people. This is very often a motivator for people to buy property jointly. There's increased buying power by doing so. Pooling resources and pooling income or pooling capital allows you to achieve buying maybe a better quality property or better located property. And then lastly, very often flexible usage options. By having property jointly, it allows you to flip between personal residence and maybe renting that property out at some point in time. If it doesn't make sense, I'll give an example in my own life. the very first property that I purchased, myself and my parents bought jointly. At that point in time, they couldn't qualify for the investment property on their own, and likewise, I couldn't qualify for a primary residence on my own. So what we did was we purchased the property jointly. We rented it out for the initial period of time. Once myself and my wife got married, we actually moved into the property and used it as our own. And years later, I purchased the shares that my parents had in that property. I took over their shareholding. So it allowed us to use the property for multiple purposes through one acquisition. Initially it was an investment property, then it became a primary residence, and then it became an investment property again for myself and my wife exclusively. So that joint ownership structure allowed us to have these options down the road. So when I say flexible usage, you might say, well, how is that relevant in joint ownership? And I think that's probably the best example that we'll be able to put together. But it's important. It comes with its own risks. It comes with the risks of managing disputes, liabilities for shared partners, and also administrative complexities. For these reasons, it's critical for you to choose the correct structure for your particular property journey. So let's get around to option number 1, joint ownership in individual names. This is probably the most commonly found joint ownership structure. As I say, partners owning property together, being husband and wife, which is why choosing is so critical. To help you make this decision, we're going to be looking at 3 major factors. One is decision making, how effective control is executed in these ownership structures. We're going to be looking at access to finance, and then lastly, the liabilities of this ownership structure. So first off, we've got the joint ownership in individual names. This is probably the most commonly found ownership structure, joint ownership structure. It's where every owner of that property owns the property in his personal capacity. So meaning the ownership, the equity is registered in his own or her own name. Spouses, husband and wife, probably your most typical example, as I've mentioned before. Now, when property is owned in individual names, important for decision-making purposes, all co-owners must consent to major decisions. These are things like selling, refinancing, renovations, whether to bond the property. All of these need to be done through mutual consent. In the worst case scenario, disagreements in this ownership structure could potentially end up in court, with the court having to enforce a sale. This is the absolute worst case scenario, but I think is also more commonly found than what you think. If you think about divorces, divorce decrees, that's very often where these sort of disagreements happen. But decision making, important thing to understand is that all owners must consent and must be in agreement for major decision making. Let's look at access to finance when joint ownership is in individual names. Banks like the combined incomes. It's easier to get the bond approval because you are the ownership is held in your own name and your income is very often derived in your personal capacity. This is probably the easiest joint ownership structure to get mortgage finance in. The only thing to remember is that every co-owner's credit record will be considered when applying for mortgage finance. So it doesn't help you have 2 strong owners and the third person is defaulting on these debt payments. That will probably result in a decline in the entire application. From a liability perspective, each owner is jointly and severably liable. This is important to understand because if one owner defaults, the others could all be responsible for the full bond amount. Again, let's use the scenario where there's 3 different owners. If one stops paying, the bank could ultimately go after the other 2 that are the remaining owners in the property. If the second one then stops paying, the bank could hold the remaining owner responsible for the full bond amount. So joint and several liability means that every individual owner could be responsible for the full bond amount. This is important to understand because when going into a joint ownership structure like this, it is very important to make sure that every single individual is financially sound. Because if one co-owner starts to default, this can affect not only the property investment, but also the other owners in their personal capacity. So what are the benefits or the pros of having this sort of ownership structure? It's very simple. There's no pre-planning required. You would simply sign the agreement of sale in both parties' names. It's extremely simple to set up and manage, and you have easier access to finance. What are some of the cons or restrictions for this sort of ownership structure? It has pretty high personal risk. Option number 2 is buying through a company. Something that I very often see, questions asked about understanding how this works. And I think very often people try and pursue these options simply because of a tax efficiency, belief that it might be more tax efficient or some form of estate planning. But I think the practical execution is very often overlooked. So let's have a look firstly at decision making. How is decisions made in a company? We've already spoken about how this indirect ownership structure works, is that the individuals own shares within a company and the company then purchases the property. So there's no direct ownership of property. It is indirectly owned through the shareholding in the holding company. Right. So decision making is governed by the Companies Act as well as the Memorandum of Incorporation for that particular company. Shareholders' agreements are essential but not necessary to prevent disputes and management deadlocks. If you don't have a shareholders' agreement, the Companies Act makes provision for this sort of deadlocks and decision making. And the purpose of a shareholders' agreement would be to deal with particular circumstances, how decision making is executed in terms of new acquisitions, sales, share valuations. All of these sort of things can be contained within the shareholders agreement. If they don't, then you simply fall back on the Companies Act. So a shareholders agreement, very important if you're entering into this sort of ownership structure, as this document would ultimately manage the relationship between shareholders. In terms of access to finance, banks are usually stricter when it comes to companies. So they will require the directors and shareholders to personally sign surety, ultimately ending up in a very similar scenario as the personal capacity. So if the company starts defaulting on its loans, the shareholders and directors could, if they have signed surety, could also become personally liable. Reality is that if the bank insists upon these sureties, you're not going to get the loan if you don't agree to them. So you could very easily say, well, you know what, we're simply not going to sign them. The reality is the bank's not going to lend you the money in that way. You could say to me, but Rowan, then we simply won't sign those sureties. The reality of the matter is if you don't, the bank is not going to give you that money. This can be applied to existing companies or to companies that are simply starting off trading now for the purposes of holding property. Remember, because your shareholders or directors may be required to sign surety, even if that company has not yet traded at all, the banks would look beyond the company and they would look at the shareholders and directors to determine whether they are financeable. What we also very often see in companies is that the banks will insist upon deposits. It's not impossible to get 100% loans in company names, but it is certainly harder than doing so in the individual capacity. So let's have a look at a scenario where, to put this in practical terms, where you maybe qualify for 2 or 3 million rand in your own capacity, but you're saying, well, Rowan, I want to use a company to sort of as the ownership structure, but I'm going to be reliant upon my income. The company doesn't trade, but you know what, let's apply for this bond and I will sign surety for the company to prove that the company can purchase. This is very doable. The likelihood of you getting 100% bond in your personal capacity, very good. If you're going through the company, that probability of getting 100% definitely declines. So remember, you're trying to set up certain safeguards, to ring fence the assets. But in the same way, you're doing that to the banks too. It becomes more complex. The banks are less favorable towards these. In terms of commercial transactions, where maybe you starting to buy commercial properties or you're buying properties for redevelopment purposes, where there might be more merit to that, and the banks might actually be friendlier to the company structure. But as an individual who's simply looking to build a property portfolio, you are probably going to have stricter credit policies with which to comply. So in terms of liabilities, the company owns the property and is therefore responsible to repay the mortgage loan. But again, remember, if you have signed surety, then you will be personally liable and exposed in terms of your surety. Again, Shareholders, directors would be required to sign joint and severable liabilities, like you would have in the joint ownership individual structure. In the case of insolvency of one of the shareholders, that will only affect their shareholding in the company and not the property itself. This is quite a big distinguishing factor between the preceding structure where we spoke about individual names. Because the property ownership is indirectly held, the insolvency will only affect their shares and not the actual asset itself. So some of the benefits and pros of having this ownership structure is that there is better asset protection. If especially if the liability comes from your personal capacity, and there may be certain tax opportunities. Again, I call this opportunities, not benefits, because it's not necessarily to say that there will always be benefits. There may potentially just be more flexibility in what options you have in the tax environment. Some of the restrictions or cons for this property ownership is that it could be quite administratively heavy, and you are not fully insulated from liability as many people may be led to believe. Lastly, with this additional administration comes additional costs. So be mindful that by having a company, you're going to have a lot more administrative and bookkeeping responsibilities. The last option is buying through a trust. Trusts are pretty complex and very often misunderstood. I often meet people deciding to buy a property through a trust, but actually trying to manage that trust as if it is their own property. In a trust structure, you as the founder and trustees, donate towards that trust. You move the property to the trust, or you purchase the property in that trust, and the property is then managed by the trustees for the benefit of the beneficiaries. Sure, trustees and beneficiaries could be the same people, but ultimately the test lies is whether that property is being managed or the benefits are being managed in the interest of the beneficiaries. So in terms of decision making, trustees manage the property in accordance with the trust deed. The trust deed is very much like in the company instances where you have your memorandum of incorporation. The trust deed would be the authority document, obviously within your legislative framework. Beneficiaries have limited or actually no decision-making powers. They could dispute whether decisions were made in the best interest of them as beneficiaries, but beneficiaries effectively have very little influence on decision-making. Trustees are the people that actually sit with the decision-making power. In terms of access to finance, trusts are probably the hardest option for bond approvals. Because of the complex structure and the nature of trusts, banks often require the trustees and founders to sign surety for the loan. Because this ownership structure is also completely detached from the founder or trustees, and the ownership is not indirect like through a shareholding in a company, this is the most furthest detached from you as an individual. For this reason, finance is the hardest to achieve. In terms of liabilities, the thing that is, as I've said before, very often misunderstood is that the trust is the owner and the sole owner of the property. Trustees would still, however, be personally liable if they act recklessly and they don't act in the benefit, or they don't act in the best interest of the beneficiaries. Beneficiaries are, however, protected from creditors. So in an example where there might be founders and trustees who have set up a trust for the benefit of their children, the children could never be held liable for the debt of the trust. However, trustees, if they have acted recklessly, they could still be held accountable, whether through the banks or through their beneficiaries. Some of the pros or benefits of this sort of ownership structure is that it offers very strong asset protection as well as major benefits in estate planning. Some of the cons or disadvantages, however, are that they are very complex and expensive to maintain. They are slow for financing and will probably be very hard to scale your portfolio unless it is cash driven. So to help you make these comparisons, I've put together a comparison cheat sheet. This can be used to just easily understand the decision-making, finance, and liability factors for each of these different ownership structures. So let's first have a look at individuals. Just to summarize, all of the individuals must be in agreement. A court can force the sale if in deadlock. When compared to a company, shareholders may, depending upon what their memorandum of incorporation and shareholders agreement say, they may require unanimous decision. In absence of a shareholders agreement or the agreements being mute in this, you would rely upon the Companies Act, which then requires majority shareholding by means of vote. In terms of a trust, the trustees would decide. Again, this would typically be by a form of vote, and the beneficiaries have limited input. In terms of financing, as we've said before, individuals are the easiest case to access finance. Their combined incomes are used when applying for finance. In a company, banks are stricter. They would usually require surety by the shareholders and directors within that company. And if the company does not have sufficient income to sustain the property acquisition on its own, they would look beyond the company at the shareholders and directors, and they would require their income to be used and then ultimately sign surety. Trusts, hardest for bond approval because the property is completely detached from the trustee. This is the hardest form of ownership to acquire a bond in, and it will almost always require surety from the trustees. Lastly, comparing liabilities. As individuals, you could be jointly and severally liable, meaning each owner could be liable for 100% of the debt. Similar in a company, even though the company owns the asset, if there is surety required, then the surety would be the same as for individuals. It would be joint and severable liability for that property exposure. Trusts, this probably offers the most protection from liability, as the trust owns the assets, but the trustees may still be liable through surety. But there's an additional layer where beneficiaries could hold trustees liable. And this might sound, sort of uncommon, but it happens a lot more than what we think. Then further, to try and put these sort of decision-making elements to the test, let's run through a couple of different scenarios of what if. What happens if a co-owner dies? What happens if I want to sell? Can my joint owners sell without my consent? What if one stops paying? And what if we can't agree? So let's have a look at the first scenario. What happens if a co-owner dies? In individual name, the shares pass according to their will. The heirs become the co-owners, and the existing owners inherit the property ownership along with the new heirs of that estate. In company ownership, the shares form part of the individual shareholder's estate, similar to that in individual capacity. The heirs inherit the shares unless there is some form of share arrangement, buyback arrangement in the shareholders agreement, or there's some form of policies as insurance. Trust ownership, beneficiaries don't inherit directly, so the trustees manage the assets. So if one of the trustees were to die, that would have no effect on the trust ownership. Let's deal with whether you can sell your shares without the consent of others. In the case of individual ownership, yes, theoretically you can sell only your share of the property unless any form of agreement between the parties exists. To sell the property wholly, all partners or all individuals would need to agree to such a sale, but you can sell your share individually. Trouble being, you won't find very many buyers who are looking to buy your share without actual consent from the other shareholders, as this could become a managerial nightmare after the fact. In the company ownership structure, you can sell your shares, but there could be preemptive rights which would apply, that come about from, the shareholders' agreements. Beneficiaries in a trust, they can't sell because they are the ultimate beneficial owners of the asset. They have no decision making in selling. In trust ownership, remember that the trust is being managed for the benefit of the beneficiaries, but they have no share which they can sell. The trustees simply control the assets for the benefit of the trustees, and thereby they control whether properties are sold or whether a share is sold or not. Remember, there's not really a share because there's no direct or indirect form of ownership. What if a co-owner stops paying? In the case of individuals, the remaining owner, would be fully liable for the bond. In terms of the company structure, the company may have rules internally in dealing with this, but ultimately the surety would take preference, and surety may affect the individual shareholders and would probably be very similar case to the individuals. In terms of trust ownership, trustees need to ensure that the payments are made, and surety will actually create exposure to them individually. So if the trust no longer is able to pay, then the trustees would become liable. Again, very often in a joint and severable manner. What if we can't agree? It's the last one that we'll deal with for now. If you can't agree in terms of individuals, the court can enforce a sale. So you would need to make an application to court, and the court could force a sale. In a company ownership, the shareholders' agreement would govern how these buyouts and forced sales work. And if the shareholders' agreement is mute, again, the Companies Act would apply. Most standard agreements would require some form of a vote, but if it requires a unanimous decision and there is a dispute, if the directors cannot agree, the decision would need to ultimately be put to the shareholders. In the trust ownership setup, the trust deed governs how the trustees can effectively execute their decision making, but the trustees have ultimate control. So again, if the beneficiaries who are the beneficial owners of the property or the beneficiaries of the asset, if they are not in agreement with the trustees, it has no effect because the trustees effectively have the ultimate control. At this point, I think rather than trying to help you decide which is the best ownership structure for you, I think I'm going to maybe give you some of perspective as to my life, and why I own property in different structures, and then maybe give you some key considerations that you can apply for all structures, which will help you determine which is the best ownership structure for you. So, as I've mentioned, the first property that was purchased, or that I purchased, was along with my parents in a trust. Myself and my parents were the trustees, and ultimately the beneficiaries of this trust would be my children, my wife, and my parents. The idea behind that would be that we could set up a property that could be multi-generational. The trust would control and own that property in perpetuity, and the benefits thereof could be distributed to those who need it, whether that be our children, my parents at a later point in time in their life, or myself and my wife, if we needed a supplementary income at a later point in time. At the time of purchasing that property, we had no intention of ever selling it. The idea was that property would be somewhere where my parents could stay if anything ever happened to one of them. My children could live if, they needed a startup home. So that was really, the idea was that property would never be sold. That was the reason for putting that property in the trust. Then for the property owned in a company, I actually own property through multiple companies, but the most prevalent example would be where it's myself and two other shareholders who have purchased property jointly. The reason for doing so at the time was that what I could qualify for in terms of a home loan and what they could qualify for individually, we felt that we could buy a typical better located property or better class property if we pooled our income. And that was how this venture started. In terms of risk and looking at ease of transacting, we believed that it would be better for us to own this property indirectly through the form of a company rather than in our individual capacities. If any of us wanted to exit at any point in time, it would be easier to do so under the company structure rather than owning the properties in our individual capacities. There's also the element of safeguarding the partnership by having the property indirectly owned. If something happened to any of us as individual shareholders, then only our shares would be at risk and not the property itself. And then lastly, I own property in my own capacity, along with my wife as an individual. Our primary residence and a number of investment properties that we own is owned in this format. The main motivators for making this decision have often been driven by the fact that we derive our income predominantly in our personal capacity. Along with this, the capital gains tax being the lowest in our personal capacities, and the benefits of the capital gains tax for our primary residence. So this combination of the lowest capital gains tax rate combined with access to finance has been the main driver behind us deciding to purchase these properties in our own names. So if we summarize, the main decision, sort of waiting in the decision for the trust was that I believed that it would be a property that I would never sell and wanted to make use of the estate planning benefits of property ownership in trusts. In terms of the company, the main decision making there was because it was a trading entity, we wanted to be fluid in terms of decision making, applying for finance, and also due to regulation of shareholders' agreements. And lastly, the main deciding factors in the personal capacity, as I've mentioned, was access to finance and the benefit of less capital gains tax. So as you can see, different factors, depending upon their weighting, may push you into a certain direction. That's why I will always say that there's no blanket answer for property ownership structures, and people that are trying to force a certain property ownership structure upon you is probably because they will benefit through it through some way or form. Key considerations for all structures that you should be taking into account is the co-ownership agreement, like we've discussed, things like decision making, contributions, how contributions will be handled, and maybe, how exits would occur, whether you would need consent, how you would go about it, the ease of actually exiting. Co-ownership agreements, whether you're buying in personal capacity, companies or trusts, should always be prioritized. From an estate planning point of view, the moment you say estate planning and property ownership, people think trusts, but this is applicable to all forms of ownership. Make sure that every partner, whether it be through a company, individual, or trustee, that every single person's will is up to date and is reflective of what the co-ownership agreement wants to achieve. If, for example, myself and the two shareholders with whom I am in partnership decide that we would like a preemptive right for the remaining shareholders to purchase a deceased shareholder out, make sure that your will and testament actually make mention of this, that you don't have conflicting documents in this regard. Even though the shareholders agreement, would regulate this in terms of the shareholding, you're opening yourself to disputes and fights later along the line. Ensure that all beneficiaries and trust structures are clearly defined. Again, not only for trusts, but also for company structures. Think about the exit strategies, plans for selling, buyouts and different scenarios, and maybe role play these scenarios between you as co-owners of this property. How will you determine the value of the property? How will you determine, the contributions that have been made? What happens if a single co-owner cannot keep up with the contributions of, the remaining co-owners? What do you do in that sort of scenario? How are you going to handle disputes? These are things that need to be openly discussed to ensure strong and viable co-ownership. Get legal advice, essentially, to avoid any complex litigation down the line. Always consult with a legal practitioner as well as a tax practitioner. These should be people that you're consulting along the way, but they should be giving you good advice based upon a holistic overview like we have tried to take today. And the last consideration, which I think is probably the most important, is clear communication. Money disputes often start with poor communication, not cash flow. By ensuring there's proper communication between co-owners, problems and issues can be dealt with swiftly, and alignment to ultimate objectives can quickly be reinforced. So as you can see, joint property ownership can be a fantastic way and springboard to set you up on this property ladder and maybe help you even jump a few steps along the way. But a structure you will choose will ultimately determine your ability to trade, the risk that you will have, and also the ease with which you will do this. Individuals is simple, but it contains slightly higher risk. Companies are structured, they are more structured, more regulated, but it protects personal assets and comes at the cost of admin. Trusts are probably the best for long-term planning and asset protection, but they can be complex and harder to finance. So the golden rule: get proper advice, plan for the what ifs, and seek legal advice upfront. So if you've been through joint property ownership, I'd love to hear your story. Share it with me in the comments, and maybe share some of your experiences and ask some questions for things to be covered in future episodes. Don't forget to like and subscribe, hit that bell button to always stay up to date with the latest deep dives for property investments from the Property Corner. Thank you for joining in.